Advocate Ishmael Jamie argues that the impact of the termination of the ZEP on its holders could only be sensibly considered when applications for alternative visas or waivers are made.
We submit that, and there are two bases for the submission. The first part of the submission is practically it is impossible to expect government to consult 178,000 permit holders, and we know that each holder has a number of dependents. So, and to the extent that an argument is made about children, etc., to consider the personal circumstances of 178,000 multiplied by 3 or 4, hundreds of thousands of persons before it adopts a policy position, that would render government's task simply impossible. It would never have been able to do that. It would have taken years to try to assess impact on that level.
Government is currently in court facing a legal challenge against the rationality and constitutionality of the termination of the ZEP. The expiry of the ZEP as of 30 June 2023 will see approximately 180,000 holders and their dependents return to Zimbabwe if their application for alternative visas are not successful or remain in South Africa undocumented. The Helen Suzman Foundation wants the court to declare that the minister's decision is unconstitutional. The foundation further asks that the decision be sent back to the minister to consider afresh in a procedurally fair manner. In response to this argument, the Minister of Home Affairs submitted that the decision was a policy decision, not a legal one, and it did not take away rights but rather conferred them.
This case concerns a policy, heavily policy-laden, overtly political decision by government. First by the minister, but then the minister sought the support of cabinet, and cabinet gave that support in November of 2021. Then it became the decision of government, the South African government. And what the South African government decided, justices, in 2021, was that it would no longer have a blanket exemption policy for Zimbabwean citizens who were ZEP holders as a category of persons who would be exempt from compliance, as every other foreigner is in this country, to compliance with the provisions of the Immigration Act. That was a policy decision. And properly understood, it's not a legal decision. And it's crucial that the court understand and appreciate that.
The Minister's Counsel further adds that the applicant is conflating the finality of the decision to not have a blanket exemption with the non-finality of the Minister and Government with respect to the individual application which has been solicited or invited for alternative visas or waivers. In its reply, the Helen Suzman Foundation said that the consultation was a regular practice and representations does not substitute it.
Secondly, that's exactly what happens via notice and comment procedures all the time. When government publishes regulations about COVID or anything else, government puts out a notice, it goes in the Gazette, it goes in the newspaper, they receive thousands of comments, and they make their decision. It happens all the time.
The matter continues on Thursday. Kani Mapanga, SABC News, Johannesburg.